Good afternoon, everyone, and thank you for participating today. My name is Corey Huffman, and I will be presenting to you on how to meet legal needs of vulnerable children. As I stated, my name is Corey Huffman, and I'm the supervising attorney here with Legal Aid Service of Collier County for the Legal Aid for Collier Kids project. The Legal Aid for Collier Kids project is funded by the generous support of the Naples Children and Education Foundation, the founders of the Naples Winter Wine Festival. So we thank you very much for the support for our project and the things that we're able to do. For those of you who are joining us today, you probably have some questions as to what we consider to be a vulnerable child. Generally, any individual who's under the age of 18, whose safety, well-being, and/or development is at significant risk due to inadequate care, protection, or access to essential services is considered a vulnerable child. Also, in our line of work, we see that children who are adjudicated dependent of the state, here in Florida specifically, children who are at risk of being abused, abandoned, or neglected, children who are in the care of relatives who are not their parents, and children with special needs or disabilities are also vulnerable children. That's generally who we help here at Legal Aid Service of Collier County in our children's project. And I'll be discussing with you today on how to meet these legal needs, what legal needs that they have, and how we are able to meet them, or how any attorney potentially could also help you meet the legal needs of children. So what legal needs do children have? Generally, like I stated, children who are dependent of the state of Florida may have significant legal needs, including but not limited to representation in their dependency action. And we'll go over that in a bit more detail as to what that entails. It also includes potential Social Security death benefits that they are receiving from a parent who passed away, or Social Security disability benefits that they may have due to a disability that they have, as well as any other legal issues that may arise from medical needs that the children have while they are in the care of the state. Children who have been abused by a parent in a request may request an injunction for protection. So generally, if there's a child who is the victim of domestic violence, and like I said, we'll get into that in a little bit more detail as we go through the presentation. Also, children may have legal needs as they go through a dissolution of marriage or paternity action. Some of the more pressing legal needs that children specifically have are relating to any special needs or disabilities that they have as it relates to their education and special education services that they should be receiving through the school. And so a lot of children we will see and have legal needs as it relates to those special needs and the education that they should be receiving. And as those children with special needs begin to reach the age of majority, there are also some legal issues that they may have if they are still unable to act completely independently on their own, and they may need some assistance from a parent or guardian to continue acting on their behalf as they reach the age of majority. So dependent children, as I stated earlier, we would consider those to be some of the vulnerable children in our state. And at that point, the state has also decided that these children are vulnerable children and that they need to be cared for by the state. So what makes a child dependent of the state of Florida? If the court finds at that point that the child should be adjudicated dependent, they have found at that point that one of the parents has either abused, abandoned, or neglected the child. And how does this happen? Generally, the Department of Children and Families will receive a report. This sometimes comes from the school, sometimes it comes from neighbors or any other concerned individual who has specific facts as it relates to the child and the family members and what the child may be going through. Once the department has received that report, they then dispatch a child protective investigator, or CPI, to investigate the allegations. In Florida, the court or the state has recognized that children and families should be able to stay together as much as possible. So when the CPI first investigates these allegations, they try to work with the family to determine what the issues are, what's causing the issues in the family. Is it because of an eviction? Is it because of lack of resources for substance abuse and the like? And then they try to offer services to the family, either therapy services, substance abuse evaluations, connections to substance abuse counselors to help the parent with these issues. They may even refer the parents to a legal aid organization like our own in order to help them get an injunction for protection if one parent is causing the abuse and the other parent is not. They may also send them for eviction help or housing assistance with the legal aid service, a legal aid organization to help the parent. So that way the parents aren't finding themselves homeless and at that point having the state needing to take the children from the parents because they are unable to provide the basic needs for the child. So the CPI, of course, try to work with the family to see if they can assist in correcting any of those issues. If they are unable to, or if the parents aren't cooperative and the CPI feels as though the children's safety is in danger with those parents, they will then ask the court to enter a shelter against the parents. So that way the child will then be in the emergency care of the state. If the court then shelters the child from the parents or the parents, the state will then file a dependency petition asking the court to then find that the child has been abused, abandoned, or neglected by a parent or both parents, and that these parents need to enter into a case plan in order to correct those issues before they can be reunified with the child. This adjudication also allows for the child to have access to services to help them during the time that they are in the care of the state. It also allows them to enter foster care, gives them the ability to receive state benefits such as Medicaid for any medical issues. It also will allow them to have some educational benefits as well as they start to reach the age of majority if they're still in the care of the state as they reach the age of majority. And how can an attorney assist in these cases? Generally, the Florida dependency system, each party of the case is represented by an attorney, and that includes the state. Each of the parents have their own attorney. In most cases, the children will be appointed a guardian ad litem who acts in the child's best interest, and that guardian ad litem that they get appointed will also have their own attorney. But during the cases, a child really has an attorney. In 2014, the legislature found that there are certain circumstances in which children should always have an attorney ad litem appointed to them, and therefore requires the court to appoint an attorney ad litem in certain circumstances. Those certain circumstances include when a child is residing in a nursing facility or is being considered for placement in a skilled nursing home, is prescribed psychotropic medication but declines assent to the psychotropic medication that they're being asked to take, has a diagnosis of a developmental disability, is being placed in a residential treatment center or is being considered for placement in a residential treatment center, or is a victim of human trafficking. An attorney ad litem works for the child and represents the child's expressed wishes. So an attorney ad litem, once appointed, they are the direct attorney for the child and directly represent the child and the child's expressed wishes, unlike a guardian ad litem who is appointed to work with the child and to offer to the court their recommendation as to what they believe is in the child's best interest. An attorney ad litem, even though specifically required in those instances, which I just discussed, can also be appointed for any other reason on the motion of the court, a motion from the state, a motion from the guardian ad litem, or either of the parents if they feel the child should have their own direct representative. Once an attorney ad litem does get appointed, they do represent the child at all phases of the dependency case from their appointment, up until the time that the court relinquishes supervision and jurisdiction over the child, or if the attorney is discharged for any other reason. As I said, the attorney ad litem works for the child's wishes with the other parties, and that could include a lot of different ways that the attorney will act for the child, including going to staffings that are held by the state to discuss how the child is progressing in their placement and if there are any changes that need to be made, so that way the child's voice is being heard during these meetings. And the attorney ad litem is going to work with the different parties to make sure that the child is able to have as much normalcy as possible. The state of Florida puts a big emphasis on the ability for children who are in the care of the state to try to have as normal of a life as possible, allowing them to stay in the same schools that they went to, so that way there's no changes there as much as possible if they can, and other normalcy issues such as allowing the children to be able to participate in activities, have access to technology that other children their age are able to access, and things like that. The attorney ad litem can also assist in arguing against placement in a higher level of care if the child does not wish to be placed in a statewide inpatient psychiatric program. The attorney ad litem would also be able to argue on the child's behalf as to why the child does not believe they meet the requirements that the state may find have been met to have the child placed in a SIP placement, a statewide inpatient psychiatric program. Generally, that requires the child to be evaluated by a qualified evaluator who does take a look at the child's psychological needs and the behaviors that may be exhibited by the child to determine whether or not that child needs a higher level of care or if a standard foster home is an appropriate placement. They can also recommend that the child be placed into a special therapeutic foster home if they do believe that they need more care than a general foster placement, but don't meet the requirements that require them to be in a statewide inpatient program, which is pretty much a lockdown facility for the child. And also during the process, the attorney ad litem gives the child counsel. As I stated, they are the child's direct representative. So the attorney ad litem and the child have a different relationship than they would a guardian ad litem. Whereas the attorney ad litem can inform the child how their life is going to be affected throughout all phases of the dependency action and how potential things that they are wanting, what legal rights they may have to those things and how to go about them. It does take some time to gain children's trust, but children who have had attorneys ad litem during the dependency action have noted that they did enjoy the process better after having an attorney ad litem who was able to talk to them about what was going on and also to argue on their behalf, where sometimes they don't feel like they always have a voice during these proceedings. We've discussed how children could have legal issues if they are dependent of the state of Florida, but there's not always that the state does find that the parents have gotten to a place where they are no longer safely able to care for their own children. But sometimes there may be an aggressor in the home and the child's safety may be at risk. And at that point, there are other options if the state does not take any action to place the child in state care, that another parent would be able to, at that point, file a petition for an injunction for protection on behalf of the minor child. If the child is under the age of 18, the child is unable to file these petitions on their own behalf. It does require a parent or a guardian to file on behalf of the child. If the state does find that the children should be sheltered from the parents, but do also believe that an injunction for protection is required to protect the child from contact between with the parents, there is also a way for the state to file an injunction on behalf of the child under Chapter 39 of Florida statutes. Also, during an injunction for protection, as I stated, the parent, usually the non-offending parent, the one that is not abusing the child or has not committed domestic violence against the child, represents the child or files the request for the injunction on behalf of the child. The court generally likes to prevent the children from being part of the litigation as much as possible. And in cases where the child has been abused or has been a victim of domestic violence, the only evidence of that abuse may solely be the testimony of the child. And at some point, the attorneys that are representing the parent or the parent may want someone to be able to represent the child's interest to try to protect the child from either having to testify or to protect the child if they do have to testify. The child could at that point be appointed an attorney ad litem or a guardian ad litem during the process of an injunction for protection proceeding. The guardian ad litem, as I stated in the dependency, will act in similar ways in a injunction for protection or other family law matter, in which case they do their own investigation, including interviewing the parties, the children, and anybody else that's involved. And then they file a report with the court recommending what they believe is in the child's best interest. And this could be for a number of things. And an injunction, it could be whether or not it's in the best interest of the child to testify. If the attorney for the parent, or if the parent wants to try to shield the child from litigation, they may have the ability to use child hearsay, where the child may have spoken with a therapist or a child protection team interviewer who determines whether or not the child has been abused. And if that at one point the therapist does not believe that the child would be able to handle testifying, the court may then be able to use hearsay that the child has told other individuals, such as a parent or a therapist, about the abuse, and have the testimony come in that way. An attorney ad litem also, as I said, would represent the child directly if they are appointed in these cases. So that while they will not file a recommendation with the court as to the best interest, they would act as the child's attorney throughout the process, meaning they'd be able to seek settlement for the child. They'd also be able to make legal arguments to the court and present witnesses as to what it is that the child wants to happen in an injunction for protection case. Likewise, if the state does not get involved and the child does not go into dependency, the child may see other issues as it relates to parents who are separating, where there may be an abuser as part of the family relationship that the other party that is not the abuser is trying to protect the child from. This usually comes in a dissolution of marriage petition, where one parent is trying to divorce the other and also prevent contact between the abusive parent and the child. And also in a paternity action, if the parties aren't married, the parents aren't married, when there is an abusive parent and the other parent is trying to prevent the abuser from having more time with the child that is not supervised until the point in time where the child's safety is no longer at risk with the abusive parent. So generally in these cases, as I said, in injunctions, the court does not want the children to be a part of the litigation, and even more so in a dissolution of marriage case or paternity action, where the parents are arguing with the court as to which parent should have more time with the child and how time sharing should be ordered, and what additional circumstances or what additional services are required of a parent to have more time with the child based on past actions. So the court does enter standing orders in dissolution of marriage cases and paternity actions, preventing either parent from informing the child of the litigation, from discussing the other parent in a derogatory manner during or at any stage of the child's life, along with other Bill of Rights that the children have in those standing orders, trying to protect them from the litigation and the facts that the parents may believe about the other parent during this time frame. And this can be difficult for vulnerable children in similar ways as the injunction case, whereas the abuse that the child may have suffered, there may be no other evidence or other witnesses who witnessed the abuse to testify on the child's behalf, and the only testimony that shows that abuse may be the testimony of the child, in which case the court may want to appoint an attorney ad litem or a guardian ad litem in order to ascertain what is in the best interest of the child, or to make sure that the child's interest during these cases is being protected at all times. In this case, similarly, the guardian ad litem would also investigate the allegations of both parties to determine to the court and recommend to the court what they believe is in the best interest of the child as to the time sharing that they should have with both parents. If there is an abusive parent, recommending what services they believe would be in the best interest of the child for that parent to take, such as parenting classes, batterers intervention courses, anger management classes, substance abuse evaluations, or any other potential mental health evaluations, to ensure that all recommendations are being followed before that parent has any additional time with the child, to make sure that when the child is in that parent's care, that the children's safety will not be at risk during that time. An attorney ad litem could also be appointed in these types of cases, and just like an injunction, then the dependency cases, they would still represent the child directly. They would not be a witness for the child, but they would be the attorney for the child, arguing for the child's express wishes and argue on behalf what the child is wanting during the process to the court, so that the child is not having to be overly involved during the litigation process. Most parents are going to kind of see special education as one of the main legal needs that they have for their children. And children with disabilities or developmental delays are entitled to certain educational supports to assist them in staying on grade level with their peers. The children may be entitled to 504 plans or individualized education plans. 504 plans are generally for children who have physical disabilities who need services and accommodations in the school to ensure that they do not fall behind because of their disability. Whereas an IEP will help with additional educational supports for those who are falling behind academically due to learning disabilities or other special needs, such as speech therapy, occupational therapy, and the like. Generally, the school is tasked with identifying children who may have special needs or who may have a learning disability, and to evaluate those children with a psychological evaluation to determine the child's IQ and where they may be lacking in certain areas, either if they are having a hard time reading or decoding, to provide additional support so that way the child is able to get the fundamental foundations that they need in order to succeed in all subjects of their school system. Once they have that psychological evaluation, the school then is tasked with creating either a 504 plan or an individualized education plan to meet those needs of the child, so that the child is receiving the additional supports, either tutoring, additional time on testing, the ability to spend more time on an assignment, so that way the child is able to fully process and show their ability to learn. An attorney can assist in these cases when the child is being with the school to ensure, one, that the school board is offering the services that are being mandated by law, and that the child receives those additional services, and that they're being properly evaluated for them, and that their progress is also properly being reported and attained to make sure that the child is able to succeed in academics. Another legal issue that most parents will see if they have a child with special needs is what happens as the child becomes 18. When the child becomes 18, the child is then able to make their own decisions as it relates to their education, and the parent is no longer having the ability to advocate on behalf of their child with the school in order to make sure that the school is continuing to provide those services. Children who have special needs and do receive special individualized education programs may have the ability to continue in the school system up until the age of 22. And at that point, there could be 4 years in which a parent is unable to help their child make educational decisions unless they have some form of guardianship or other legal document allowing them to make decisions on behalf of the child. Once the child turns 18, they're no longer considered a child. And so if a parent or guardian is wishing to seek some form of additional legal authority over the child in order to make those decisions, they would have to file for a guardianship or guardian advocacy. Guardian advocacy would then make the child a ward of the person who is the guardian. And with children who have developmental disabilities, there is an easier process, like I said, the guardian advocacy, which would give them the same rights as a guardian would without having to have a full plenary guardianship over the child, but would allow them to make decisions for the child that directly affects their developmental disability, preventing them from making those decisions on behalf of themselves. In those types of cases, the court will automatically appoint an attorney ad litem to each of the children or each of the wards in that process to make sure that the ward understands the process during it and understands what rights the ward may lose if the court enters a guardian advocacy over the ward, or if the court does find that the ward is unable to make their own decisions and that a guardian should be appointed to them. So they will have an attorney ad litem who assists them through that process, so that way their interests are protected. as I stated, I'm with the Legal Aid for Collier Kids project, and our project was created to assist the vulnerable children with their various legal situations here in Collier County. Like I said, that is thanks to the support of the Naples Children Education Foundation, the founders of the Winter Wine Festival. And we offer services in Collier County for a lot of specific reasons. We represent parents in an injunction for protection case, dissolution of marriage, or a paternity action when the child is at risk of being a victim of domestic violence or at risk of being a victim of being abused, abandoned, or neglected. We also represent relatives who are caring for children that they are not the parents of, a child whose parents are unable to provide the care and have placed the child in the care and custody of a relative. Usually we see this with grandparents, aunts and uncles who now have a child that they need to be able to care for their basic needs and may not have the legal authority to do so. We do represent those relatives in order to get that legal authority to make sure that the child is receiving an education, and if they have any medical needs, that the relative is able to make sure that the child's medical needs are met. We represent children when we're appointed to them in the dependency system in Collier County. We also represent children with their educational needs once we are appointed to them in the dependency system, and also parents who are seeking that assistance privately can come to legal aid and ask for this assistance if they believe the school is not meeting their educational needs. We also represent parents whose children are reaching the age of majority who have developmental disabilities and require ongoing decision-making authority over their child in a guardian advocacy program. Legal aid also offers a number of other services such as housing assistance. Like I stated at the beginning, when the CPI first gets involved, one of the reasons that the children may be at risk of being abused, abandoned, or neglected specifically in this instance, is if the parents are unable to meet the rent and may be evicted from a house, we may be able to refer them to our housing program to assist them, so that way the child is not at risk of being neglected because of the inability of their parents to provide proper housing for them. Also consumer assistance and tax preparation assistance in our low-income tax clinic. Legal aid likes to provide a holistic approach to all of our clients. Specifically in our children's unit, we like to make sure that our children are receiving all of the benefits that they can, and if that requires us to refer their parents to other instances or other programs in order to receive food assistance programs or housing assistance, that they're receiving those services so that way they're properly able to care for their child and that the child does not fall through the cracks or have to enter into the state dependency system due to their inability to do that. At this time, I'm finished with my presentation, so if we have any questions, though I don't know that we have any other participants in here with us today, but you are welcome to contact Legal Aid Service of Collier County at 239-775-4555 for an intake and to determine what services, if any, we're able to offer you. Thank you.